Good afternoon. Welcome to our third now lecture as part of our J6 lecture series. And for those of you who don't know, the J6 is the junior members of Chambers of Red Lion. And we, for the past year or two now, have been putting on lecture series in relation to topics that we think might be relevant to junior members of the bar or more junior solicitors. We're trying to make them as interactive as possible. The idea is that if you've got queries or if you've got questions, please post it in the box. You'll see there's a Q&A box. I'll be monitoring it, and it may be that Tom and Sam can address those questions as they go along. And if you do miss any parts of it, the lecture series is recorded and uploaded on our website. And also the slides will be there as well. So you can use that as a reference tool later on. What I will say is that you may notice that Sam Smart is not here. He's been held up in court, but he's due to be logging on within the next 15, 20 minutes. So Tom is going to go first, talking about the new sentencing code. And then Sam will be addressing you in relation to hospital orders. Like I said, it's very casual, very informal. So please do post any queries in the box. And unless there's anything else, I'm going to hand it over to you, Tom. I will mute myself and take off my camera.
Thanks, Nick. Hi, everyone. Thanks so much for joining. I'm giving the first of the two talks tonight, looking at the new sentencing code. It's been in force for a few months now. That's being used across the country by courts. I think it's still new to many people, certainly to myself. So I wanted to look in more detail at it tonight and look at what it is, what it does, what it covers and doesn't cover, and finally why it's so important. So turning to the first question here, really, what is it? It's encompassed in the Sentencing Act 2020. Like I said, it came to force quite recently, the 1st December 2020. It's an ambitious piece of legislation that's designed to bring all existing, or at least the majority of existing sentencing law, together into one consolidated sentencing code. Now, the problem with the previous sentencing law is that there are a huge number of separate statutes that were frequently amended and brought into force at different times. So what would happen is there'd be multiple different versions of the law that could apply to a given case, depending, for example, on the date of the offence. It was extremely complex. Judges and practitioners had to wade through separate, different pieces of legislation, trying to find what was the correct sentencing law to apply in a given case. It was agreed by all parties involved that there was an urgent need for reform. And so the Law Commission undertook a project to create a single statute containing all the law on sentencing procedure. They carried out extensive research and they put together and consolidated the current sentencing regime, and they saw that it spread across over 50 acts of parliament. They compiled it into a single document, and it was over 1,300 pages long. And this contained provisions from statutes as varied as the Justice of the Peace Act 1361 to the Dangerous Dogs Act 1991. The idea, of course, is to synthesize this into one sentencing code, which is what we have, which is itself still quite long, but at least it's in one place. It's 420 sections and 29 schedules. Following a number of consultation exercises and issues papers, the Law Commission published this draft sentencing code alongside an accompanying report, the 22nd November 2018, and I give a citation to the report in the slides. That report is extremely useful in answering essentially any question about the sentencing code itself. But the main aims, the benefits that it sought to introduce is what I have on the slides there. The first is just to make the law simpler and easy to use. The second is to increase public confidence in the criminal justice system. And the third is to increase the efficiency of the sentencing process. But to look a bit more detail at exactly what it does and what it seeks to achieve, the first point is perhaps the most important point. It tries to help stop unlawful sentences by providing a single reference point for the law of sentencing and simplifying many complex provisions, and indeed removing the need to refer to historic legislation. An analysis conducted in 2012 of 262 randomly selected cases in the Court of Appeal Criminal Division. of those 262, 95 involved unlawful sentences. And this wasn't just sentences which were considered to be of inappropriate severity if they were a manifestly excessive or increased on the basis they were unduly lenient. But there are also cases where the type of sentence imposed was simply wrong in law, which is exactly what the new sentencing code is trying to combat. Another major achievement that it hopes the sentencing code will introduce is saving money, saving cost. There was a full impact assessment carried out by the Law Commission with a full economic assessment, and that said that it would be savings of up to £256 million over the next decade by avoiding unnecessary appeals and reducing delays which clog up the court system. Another point was just to allow non-lawyers to understand sentencing more easily. Indeed, it was difficult enough for lawyers. One way of achieving this was to rewrite the law, the sentencing code, in more modern language. Drafting changes, for example, using gender-neutral terms, using the term children rather than youths, young offenders, or juveniles. But another apparently innovative drafting technique they came up with was what's called cross-referential drafting, which sounds very fancy, but essentially just means signposting. On the next slide, I'll show an example of one of the sections, but all it means is that when you're going through the sentencing code and you're looking at different provisions and wondering, well, how is this defined, or what do I need to look at next? It will just say in brackets, C section, whatever. It means that when you're running through the code, judges or practitioners, they easily know where to go next because it's actually signposted rather than having to wade through and look at different historic acts from 50 years ago to try and find definitions or find the commencement provisions. Another point I have on the slides always talked about is removing unnecessary layers of historic legislation. There's now one act rather than 50. And finally, allowing judges to use modern sentencing powers for both current and historic cases. This is something I'll move on to because it's very important, but essentially this is achieved through the use of the clean sweep mechanism, which I have a separate section of this talk dedicated to. This is an example of one of the sections. As you see, it doesn't have any reference to anything outside of the Sentencing Act, although there are parts of the Sentencing Act where if certain provisions haven't been able to include within the Sentencing Act, it will say, for example, see the Road Traffic Act, but generally they try and keep everything in one place. So as an example, if you're going through this, looking at the availability of extended sentences of detention, you can see that it's available under section 254, where a court is deeming an offender for an offence if A, the offence is a specified offence. If you're wondering what that is, it says go see section 306, you can easily find that. And it is listed in the table in section 249. Again, you don't have to go to a separate piece of legislation for that. This is carried over throughout the whole of the sentencing code. And indeed, if you see at the bottom, it will have other areas you need to look at, for instance, pre-sentence report requirements. And again, it will cross-refer to the C section 30. So it's all contained within one piece of sentencing code material. Looking at what it doesn't do, though, it's important to note a few things about what the Sentencing Act doesn't actually do. The first is that it doesn't alter the maximum sentences for criminal offences. The Sentencing Code merely consolidates the existing sentencing regime. It doesn't provide substantive changes to the law in that sense. Another very important safeguard that's built into the Sentencing Code is that it doesn't subject any offender to a harsher penalty than that which could have been imposed at the time of their offence. In creating the code, the Law Commission were very well aware and very careful to ensure that it wouldn't fall foul of the general common law presumption against retroactivity and the protection afforded by Article 7 of the European Convention of Human Rights against retroactive criminalisation and retroactive punishment. And again, this is something I'll go on to later when I explain this clean sweep mechanism. Another thing it doesn't do, it doesn't extend minimum sentencing provisions or create new minimum sentences. Again, it's a consolidation exercise rather than substantially changing the law in this area. It doesn't reduce judicial discretion. It maintains the existing sentencing framework within which judges operate. It means that they can better navigate it rather than restricting them or reducing their discretion. And finally, it doesn't replace the sentencing guidelines or the work of the Sentencing Council. The Sentencing Code sits alongside and works with the sentencing guidelines. In fact, all of the sentencing guidelines have now been updated to include relevant references to the Sentencing Code. And indeed, the Crown Court Compendium has been fully updated in regard to sentencing as well. Looking at the structure of the code itself, it is a large piece of legislation, a large piece of material, but it is logically set out, and it's designed to be a lot easier to follow than looking through different acts. And indeed, the structure itself follows the structure of a sentencing exercise. There are 6 groups. It's probably easiest to go through these groups. I put that on the left. You can see the way it's broken down in the act on the right. The first group is very short. It's not strictly the code itself. It's more the act introducing the code. It just provides an overview and a description of the application of the code. And all it really says is that it doesn't apply where someone is convicted before the commencement date, which is the 1st December 2020. The second group are the general sentencing principles that apply to all courts. The first to do with powers exercisable before passing sentence. So, for instance, deferring sentence, committal to the Crown Court for sentence, or remission to the Youth Court. It then has general court procedure during sentence, so pre-sentence reports, ordering payment of the statutory surcharge, the duty to give reasons and explain the effects of the sentence. As well as that, it has the exercise of the court's discretion in determining sentence, so using the sentencing guidelines and determining seriousness. The third group then looks and deals with the specific disposals that are available to the court, of which we're all well aware: absolute and conditional discharge, referral orders, fines, compensation orders, driving disqualification, youth rehabilitation orders and community orders, and finally custodial sentences. And within custodial sentences, that is split out logically between those aged under 18, those between 18 and 21, and those over 21. And previously, that had been a huge issue in terms of courts trying to determine exactly what custodial sentence they can give for people in those 3 categories based on their age, whether it was a detention and training order, or a youth offender institution custodial sentence, or an adult custodial sentence. So that now should be a lot clearer, because you can just follow through the sentencing code and it'll be signposted where appropriate as to what the court can and cannot do. Also deals with suspended sentences, dangerous offenders, minimum sentences, and life sentences. The fourth group then deals with behaviour orders, and the common ones we're all aware of again: criminal behaviour orders, CBOs, sexual harm prevention orders, SHOPOs, restraining orders, and parenting orders. So all the law and legislation that previously applied to sexual harm prevention orders, that now is all contained in the code. You don't need to look elsewhere, it should be there. The fifth group then are miscellaneous provisions. So simply costs, fines, and financial orders where the offender is under 18, or commencement and alteration of sentences and interpretation provisions. And the sixth group are basically supplementary provisions. It deals with amendments to the sentencing code, as well as other provisions they just couldn't really fit in anywhere else. It is important, though, on the point about amendments to the code. The sentencing code itself is intended to be a living document. So if any future changes are made to the law on sentencing, they're made through amendments to the sentencing code, rather than piecemeal separate acts, which created the very problem that led to the code in the first place. The good news is that this is already being followed. An example is the controversial police crime sentencing and courts bill. If you look at the bill on that, you'll see it contains provisions which amends the sentencing code in line with the changes it made. So it's not creating a separate new piece of legislation for sentencing that you have to then look at, as well as looking at the sentencing code. The idea is it directly amends the sentencing code. So all you have to look at is the sentencing code. Everything's kept in one place. And this should be how it should be going forward with new legislation. Looking at what's not included in the code, as I said, it covers a lot, but it doesn't cover everything. And some areas were not included for a variety of reasons. One area is sentencing council, governance, and constitution. Provisions covering the existence and governance of the sentencing council itself weren't deemed necessary for the sentencing code. They exist alongside the sentencing code, but you have to bear in mind what the code is for. That the code is designed to be used by judges and practitioners at the point of sentencing to assist with the sentencing exercise. the constitution and remit of the Sentencing Council was irrelevant for those purposes. Disposals for road traffic offences. Now, the code doesn't restate or replace the Road Traffic Act, so it doesn't deal with penalty points. It does have a section, which I've already briefly mentioned, on driving disqualification, but it refers to the Road Traffic Offenders Act 1988. The Road Traffic Act 1988, the main road traffic acts that deal with road traffic disposals, they already themselves form a self-contained code governing sentencing in road traffic offences specifically. One of the reasons why it wasn't included, and it's set out in the Law Commission report, is that they frankly just didn't have the time. And they stated that inclusion of road traffic specific material did not represent an efficient use of resources, even though some hoped that it would be included in the sentencing code. Position is slightly similar with confiscation under POCA. Again, POCA, the Process of Crime Act 2002, provides its own self-contained, albeit amended code governing confiscation. So it wasn't felt the need to incorporate what is its own self-contained regime. Another point, though, is that in relation to confiscation, the Law Commission didn't consider that confiscation was strictly sentencing. Sentencing, they determined, was to punish, deter, or rehabilitate, whereas confiscation is to remove illegitimate benefits obtained from criminal conduct, including a criminal lifestyle where appropriate, and it forms separate proceedings from sentencing. Another reason they didn't include it was that because the Law Commission had already begun its own separate review of the confiscation regime, they completed the consultation phase on that, and they're aiming to produce a final report in spring 2021. So that's expected soon. Other areas that aren't covered, release and recall. Release and recall provisions, again, this is not something that's dealt with by judges and practitioners at the point of sentencing for the sentencing exercise that they need to do. It concerns the administration and enforcement of sentences, which occur really after the sentencing process, and they are therefore outside the scope and purpose of the code itself. Another one, appeal and Attorney General's references, but really it's the same reason. This is not part of the actual sentencing exercise which the code is concerned with. By definition, appeals arise after the sentencing exercise has been completed, although there is a notable exception. And the slip rule powers are included in the sentencing code because they are carried out by the judge who imposed the original sentence at the same court. So these are now at section 385 of the sentencing code, alteration of Crown Court sentences. The penultimate area not included, common law rules. Newton hearing rules, Goodyear rules. The problem here is that these would first need to be codified into some form of legislation, so that they could then be consolidated. The process of the Sentencing Act was to consolidate existing codified legislation. And so they felt that that really went outside of this consolidation exercise. Final point here that's not included is mental health disposals, which I expect we'll hear a lot from Sam on soon. Initially, the Law Commission decided that this should be included, but then decided against inclusion. There are about 3 reasons that they seem to give. The first is, again, somewhat similar to confiscation. They didn't feel that this was in the scope of what they deemed should be within the sentencing code, because they said this code should apply to sentences that follow conviction, whereas these were more disposals without conviction. They should be a separate regime. The second point they raised is that, again, just time and resources were scarce and they didn't have the time to put them in to make sure they did a good enough job on the rest of the sentencing code. And the third was they themselves recognised, the Law Commission, that the provisions of that regime for mental health disposals, they themselves needed to be properly consolidated into the Criminal Procedure Insanity Act 1964. They needed someone to create a single enactment containing all the relevant aspects of mental health disposals. The Law Commission recommended this be done, someone do this, but this should be done separate to their process of consolidation that created the code. Something I've mentioned earlier, it's a very important and innovative part of the code, is this clean sweep, this idea of a clean sweep mechanism. And this is meant to fix this large problem I mentioned at the beginning that's plagued the previous sentencing regime. with multiple different acts spread across different times and different commencement dates. The problem under the old regime is that different sentencing powers were available depending on when the offence was committed, and it was difficult for courts to try and figure out exactly what powers they had in the case of each offence, and the date of that offence and the age of the offender and various other factors. The way it works now is there's a clean sweep. So the sentencing code, the powers contained therein, apply to all convictions on or after the 1st December 2020. Everyone convicted after that date is subject to the same regime, and that's completely regardless of the date of the commission of the offence. Now, there are some circumstances where judges will be sentencing for some convictions before the 1st December 2020, so pre the code, and then some after the 1st December where the code now does apply. But the code has included transitional provisions at Schedule 27, and also as time goes on past the 1st December, these instances are quickly diminishing. A very important safeguard, I've alluded to this already, has been built into the code, and that is to safeguard against retrospectivity and Article 7 infringements. As I've already said before, it means that no one is at risk of being sentenced to a heavier penalty than could have been imposed at the date of the commission of his or her offence. Where there is any risk of a breach of the principle against retroactive punishment or Article 7 of the ECHR, the code has already provided for this. It's included, embedded within the code, the relevant date range and the lesser harsh penalty. So when you use the code, you don't have to worry about maybe I should be using a different piece of legislation in case this is infringement of Article 7. The code has been created in such a way that these safeguards are already built into it. Now, the way the clean sweep mechanism actually operates and the way these safeguards operate is actually really very complicated. It's achieved through a separate piece of legislation enacted prior to the Sentencing Code called the Sentencing Pre-Consolidation Amendments Act. In the Law Commission report, there are about 25 paragraphs dedicated to explaining the technical operation of the clean sweep, and they liken it to a mathematical formula or an algorithm. For those interested, I really encourage you, please look at the technical explanation in the report. I'm afraid it goes a bit beyond my talk today, and the report itself exercises that users of the code do not need to understand how the clean sweep works. It's a technical drafting device which is embedded in the code. You just have to follow the code. What is useful to understand, though, is the effect that the code has and why it's important, why it makes the code important, this clean sweep effect. This is best illustrated by way of an example, and this example they give in the Law Commission report. I've set this out in full on this next slide, so you can sort of read it with me. If you take an example of a 25-year-old man, he pleads guilty to an offence of domestic burglary, contrary to Section 9 of the Theft Act. The offender has had a dispute with a neighbour who he believed was transgender, gained entry to a house by forcing open its downstairs window. He spray painted a transphobic slogan on the wall of the lounge. Limited damage to property, nothing stolen. The offender committed the offence impulsively after an argument with the neighbour one evening. So looking at the sentencing guidelines for burglary offences, the offence appears to fall within Category 2, has a range of a high-level community order to 2 years custody, and the offender has a previous conviction for burglary in France in 2004. So that is the factual matrix. And as you can see, there are lots of different aspects of that factual matrix. Previous convictions, the transphobic element, the availability of a suspended sentence, for example. Now, under the old law, the previous sentencing regime, very different powers would be available to the courts depending on when the offence was committed. And that's even if the date of conviction or the date of sentence is the same. This is best illustrated through this table on the next slide. So if we take that same factual matrix, that same facts for that offence, and we see it, for example, committed on 3 separate dates, 1st of January 2005, 1st of May 2010, 1st of November 2018, depending on when it's committed, the court has vastly different powers, vastly different ways it would have to deal with that offence for sentencing purposes. And the first, if the offence was committed on the 1st of January 2005, the court would not be under a duty to actually follow the sentencing guidelines. It would be under a lesser duty just to have regard to them. And this is because that duty to follow only applies to offences committed on or after the 6th of April 2010 by Section 125 of the Coroners and Justice Act 2009. Another point, if you look at the previous conviction in France, if it was committed, this offence, in the 1st of January 2005 or the 1st of May 2010, again, there wouldn't be any duty to treat the previous conviction in France as an aggravating factor, because the duty to treat previous convictions in a European member state only applies to offence committed on or after the 15th of August 2010. Another example, the requirement to treat as an aggravating factor the fact the offence was motivated by hostility relating to transgender identity, and then to declare that an open court, that doesn't apply to sentencing on the offence committed before the 3rd of December 2012. So it only applies if the offence was committed in that last example, the 1st of November 2018. And finally, looking at suspended sentence orders, this is only available, actual suspended sentence orders, for offences committed on or after the 4th of April 2005. So if it was committed, as that example suggests, on the 1st of January 2005, the court would instead have to have recourse to historic sentencing powers under the Powers of Criminal Court Sentencing Act 2000 to impose a suspended sentence. But crucially, under that regime, it wasn't possible to impose requirements as part of a suspended sentence. So the court wouldn't be able to require the offender to participate in activity designed to address his transphobia. The sentencing code seeks to basically solve this problem. So if the defendant was convicted after the 1st of December 2020, when the sentencing code is in force, he would be subject to the same sentencing law and procedure, irrespective of when the offence was committed. So all those powers would be available, irrespective if it's 2005, 2010, or 2018, so long as he's convicted after the 1st of December 2020. Essentially, under the sentencing code, all of the boxes in that table would be Y for yes. And the final point I wanted to touch on is looking at the main reason why the code is important with some examples. Really, the main reason is this multitude of sentencing errors that have occurred because of misapplications of sentencing law, given its complexity, without it being together in one single place in the sentencing code. There have been many times, and I could go on to these examples, where judges have imposed sentences that are simply unlawful, being unaware that the sentence they have imposed in that case is simply unavailable in law, or the converse, failing to impose the proper sentence. There's potential for serious injustice. The first example shows this very clearly. The case of GJD, 2015 Court of Appeal Criminal Division. The offender here received sentence of imprisonment for public protection, IPP, the minimum term of 6 years under Section 225 of the Criminal Justice Act. Committed an offence between August 2004 and January 2004, and he was sentenced sometime later in August 2006. Now, Section 225 concerning IPP had been brought into force when he was sentenced, but crucially, it only applied to sentences committed on or after the 4th of April 2005, whereas his offences were committed before then. Neither the judge nor counsel realised that actually the offender could not receive an IPP sentence in law. Nearly 10 years later, February 2015, this was now 2 years and 6 months after the expiry of the minimum term, the offender appealed against sentence, and the court had to quash the IPP sentence and replace it with a determinate sentence of 12 years, which meant he was immediately released. The Lord Chief Justice at the time, Lord Thomas, commented, "It is astonishing that the fact that the judge had no power to pass that sentence was not recognised for a considerable period of time. It was not recognised, for example, when on the 22nd of November 2011, and bear in mind the appeal was February 2015, 22nd November 2011, the minimum term expired. The applicant's case was reviewed by the parole board on 4 occasions, the last in January 2014. Another example I give there, the case of Thompson, shows the converse. Here, the judge failed to impose an extended sentence when he should have done. The defendant was convicted of Section 18 GBH, sentenced to 12 years detention. When passing sentence, the judge expressly found that he was dangerous, but wrongly believed that because he was below the age of 18, he had no power to pass an extended sentence. It is noted in the judgment that it's unfortunate that counsel did not draw his attention to Section 226B of the 2003 Act, which specifically gave him the power to do so. Well, notwithstanding what might have been considered good fortune of the defendant, he appealed against his sentence. Unsurprisingly, the court found it wasn't manifestly excessive, and they noted that the only error in the sentence passed was not to impose an extended sentence as the judge could and indeed should have done. However, in that case, the court could not then extend the sentence, for to do so would be to pass a more severe sentence which would fall foul of Section 11.3 of the Criminal Appeal Act. The final case I quickly just want to mention is quite a well-known case, Long, Henry and others. It's an appeal against sentence that was heard very recently, end of last year, and regarded the very publicised killing of PC Andrew Harper. Many of you will be aware he was killed after being dragged behind a car for more than a mile by 3 teenagers who were suspected of stealing a quad bike. All 3 of them were convicted of manslaughter and conspiracy to steal. They appealed against their manslaughter sentences, and this was refused. But I remember this from reading the judgment. There were issues with the sentencing that hadn't been picked up by anyone. It was stated in the appeal judgment that a point arose which was not the subject of any ground of appeal, but had been identified by a case lawyer in the Criminal Appeal Office. And this was that because 2 of the defendants were still 17 when they were convicted of the conspiracy to steal, a sentence of detention in a young offender institution, which they received, could not have been imposed in law for that offence. Such a sentence was only available for those aged 18 to 20 when convicted. Although no one noted the error at the time, the only custodial sentence available for that offence, not the manslaughter, but the conspiracy to steal, was a detention and training order. The maximum term of that was 24 months, when actually they received detention in a YOI for 38 months. There was no proper ground for that YOI sentence. It had to be quashed. It was unlawful, and it was replaced by the DTO, which was actually reduced to 18 months to reflect their credit. In this case, it had no practical effect because it didn't affect the sentences for manslaughter, most of which, the sentences for manslaughter ran concurrent. But it does show that even in high-profile cases, mistakes are made. And because of that, the sentencing code is extremely important in ensuring that going forward, those mistakes are not made. Thanks for listening. That's the end of my talk. I don't know if any questions are received in the Q&A. I couldn't see it while I was giving my talk, but I'd be happy to try and answer any.
I think you're off the hook. There's no questions as of yet. But similarly, if people want to email in questions at a later date, I'm sure Tom is more than happy to help. You'll be pleased to know I'm not doing an off-the-cuff talk on hospital orders because, in fact, Sam Smart has arrived fresh from court, and he's going to be talking to you about hospital orders and their implication for defendants. Thanks very much, Tom. Good luck, Sam.
Thank you.
Yeah, all right. I'm going to try and share my screen and see if this works. Can everyone see that? Nick, if you could just give me a thumbs up that you can see that. Great. All right. Thanks very much, everyone. I'm sorry I'm late. I was trapped in court and everyone was having so much fun at the trial that no one wanted to leave. We've got quite a lot to cover today. So what I'm going to do is get cracking. There's a little bit of housekeeping, first of all. The first is to say that these slides, they stand as the speaker's note. So they're quite wordy. So there's no need to take notes. Indeed, if you're doing the cooking washing, there's no need to watch. Also, there's quite a lot of content to cover. So if you have any questions, put them in the chat box with an email address and I'll get back to you. That's not very helpful. Right. So first question is, well, what is a hospital order? And Archbold defines it as a hospital order is available to the court where an offender is convicted of an offence punishable with imprisonment, and on the evidence of 2 registered medical practitioners, the court concludes that the offender is suffering from a mental disorder, And the court concludes that the most appropriate way of disposing of the offence, considering all the circumstances, is for the offender to be detained in a hospital for treatment or placed in the guardianship of a local social services authority. The key things to take here really are it's an offence punishable by imprisonment, and where you have two registered medical practitioners saying that the offender is suffering from a mental disorder, that the most appropriate way for them to be dealt with is to be detained in hospital for treatment. I mean, that is it in its purest form. It's important to note, and the case law says there that the purpose of a hospital order is rehabilitation and protection of the public. It is not concerned with punishment. When are they available? Well, thank you, Tom. They are available on conviction, and they're also available when the defendant is unfit to plead or found guilty by not guilty by reason of insanity, and that is from the Criminal Procedure Insanity Act. And there are also interim orders which should be considered. But for the purpose of this presentation, we're primarily going to look at the regime on conviction. So, the title of this presentation is Practical Considerations. Well, what are the practical considerations? And I think there are three. The first thing is start at the end. I think about what's the ultimate question you're going to have to answer at the hearing, and everything needs to work towards that. And the second is know the sentencing considerations. I think Tom and the Law Commission have it quite right. This is an area of law that is crying out to be consolidated properly, because it is a bit nebulous. So know your way around it and know it well, because it is important. And the third thing is utilize your expert. Your expert is really the key to attaining hospital order for your client, and they can also do a lot of the heavy lifting for you when it comes to the hearing, when you have some of the more difficult questions to answer. So let's work through that then. So what do I mean by start at the end? Well, think about what the judge will have to decide in order to grant your client a hospital order. And I suppose the key question is, well, what is that, Sam? And it is in the case of Voles, as confirmed and clarified in Edwards. There are essentially two things you need to be looking at. First, and this is stage one, and it's set out here, when making the choice between a hospital order with or without restriction and a custodial sentence, they'll consider these criteria. And essentially, this stage is, well, custody or hospital. That's the thing that they're really looking at. And as you can see there, the criteria that the court must consider are things like the extent to which the offender requires treatment, and the extent to which the offending is attributable to the mental condition, although that's not determinative, and the extent to which punishment is necessary. And again, this case law on that, talking about that, and essentially looking at harm and culpability. The need for protection from the public, including the regime upon release, and that's very, very important when you look at different types of orders, which we'll come on to. And the nature of supervision after release. Again, there are different types of orders that can affect that. So that's stage one. And I think that's something that can fairly comfortably be handled, and is the sort of thing that we do all the time when it comes to sentencing practice, for example. But then when you look at the second part of the sentencing considerations, I think this is where it gets a little bit more complicated, and it's good to know the framework, because the framework is in some ways slightly cyclical. So when considering whether a hospital order, with or without restrictions, is an appropriate way of dealing with the case, the court should first consider whether the case has been adequately dealt with, could be adequately dealt with by a hospital and limitation direction. And so for anyone not au fait with hospital orders, you're probably looking at that, because this is the type of order, saying, well, hang on a minute, I know that we're here to talk about hospital orders, but what's restriction? And indeed, what's a hospital and limitation and direction? And essentially, these fall under three sections of the Mental Health Act. So Section 37, Section 41, and Section 45A. And these are the three things you need to consider. And if I can go back a slide, actually. Essentially, before considering a hospital order, you need to consider whether you should have a hospital order with restriction. And before whether you consider a hospital order with restriction, you need to consider whether you need a hospital and limitation direction. And so what I'm going to do is I'm going to take those in reverse order, so you can see how they work, how you qualify, and then how they work together. So that's going to be the structure of the talk. So let's look at the hospital orders. What is a hospital order? I've already described that, but that's just for completeness. Well, how long do they last? Well, a hospital order lapses after 6 months, but it may be renewed for a further 6 months, and then at yearly intervals thereafter, where the responsible medical officer, essentially their primary clinician, considers further detention is necessary for the protection of the public, or is it in the interest of the patient's health and safety. And there's actually no limit to the number of renewals. It can be renewed indefinitely. The patient can, however, be discharged from hospital by the various powers that are exercised by the responsible medical officer, hospital managers, or indeed the first year tribunal. And it's important, the last point is important, a responsible clinician can discharge the patient under a community treatment order, which makes the patient liable to recall to hospital. That's important for a lot of clients, because essentially under a community treatment order, the defendant, or the client, whatever you want to call them, can essentially still be subject to the hospital, but can actually be sort of semi-discharged into the community to receive community treatment support, which will allow these people to return to their support networks and things like this, which will obviously help in their rehabilitation. So that community treatment order element is very important. So how do you qualify for a hospital order? Well, this is the test that's set out in the statute. So the first part is section 37(1). So where the person is convicted before the Crown Court of an offence punishable with imprisonment other than an offence for which the sentence is fixed by law, or convicted of a magistrate's court of an offence punishable by summary imprisonment, and the conditions met in subsection 2 are satisfied, the court may authorise admission and detention in a hospital. So what are the factors at subsection 2? Well, subsection 2 is in 4 parts, but here are the first 2. So the first is that the court is satisfied on the written or oral evidence of 2 registered medical practitioners that the offender is suffering from a mental disorder, and that either the mental disorder from which the offender is suffering is of a nature and degree that it makes it appropriate for him to be detained in the hospital for medical treatment, and that treatment is available for him, or, and then there's a section on guardianship orders, which we're not going to cover today, but we can do in another session. So let's look at that then. So the conditions at 37(2), the court is satisfied on the written or oral evidence of 2 registered medical practitioners. For the purposes of section 37(2), at least one of these 2 medical practitioners must be approved for the purposes of section 12 by the Secretary of State as having special experience in the diagnosis or treatment of a mental disorder. So essentially, when you're looking at instructing experts, make sure that at least one of them is on this list, is on the list and suitable for this referral. And frankly, in practice, one of the practitioners is likely to be your client's primary physician, and indeed that may be the one that you decide to call for any hearings. And this essentially becomes the thrust of your expert evidence. And these are the points that form the basis of the expert report, and instructions to experts need to reflect this. It is about the nature and the degree of the disorder, why a hospital order is appropriate, and indeed availability of treatment, which we'll come on to. And this is also something that will need to be highlighted in the examination in chief at the hearing. So make sure that you have this from an early stage. In terms of the third criteria, it's that the causes of the opinion having regard to all the circumstances, including the nature of the offence, character antecedents of the offender, and the other available methods of dealing with him, the most suitable method of disposing of the case is by order under this section. Now, this is likely to be dealt with in your submissions, in the submissions that are made to the court. However, again, this is where you utilise your expert. If you can get the expert to touch on some of these areas, you can get them to do a lot of the heavy lifting, because the judge is going to want to know essentially about the background of the case. So if you can get your expert to talk about that, to talk about maybe perhaps even the client's mental state at the time, and other methods of dealing with the client, including other orders and their opinion on those, and that can be a very, very useful way of getting some semi-independent view on the subject before the court. And so the next part is there room for them? And I suppose this is the key thing. So the order can only be made on the written or oral evidence of the approved clinician who'd be in charge of the offender's treatment, and that the arrangements have been made for the offender's admission within 28 days of the order. So paraphrase, is there a bed for them? Again, this should form part of the written advice, and indeed form part of the examination in chief at the hearing if you're calling the primary physician. And I'd say the watch out here is that care needs to be taken to ensure that there is a bed, first of all, but also that they can be transferred. I think one of the issues that a lot of prisons and hospitals are having at the moment is the transfer of patients. And you don't want to end up in the situation where the 28 days lapses and then you have to apply for the order again. So when it comes to organising this, make sure that the hospital and the prison are at least in conversation to ensure that they can be transferred within the 28-day window, which is something that I think a lot of places are struggling with at the moment. Just a quick note on is there a room for them? There's no legal obligation for health authorities to accept offenders from the courts. However, there is a legal obligation to supply information about the availability of beds in their region. So you might not be able to get to the hospital you want, but you might be able to get information in the region. And in an emergency arising within the 28 days, the Secretary of State may give directions for admission to a hospital different to that stated in the order, which is obviously going to be suboptimal if your client is engaged with a physician at a certain hospital. Another thing to bear in mind is it's not necessary that the offender should be admitted to a hospital in a part of the country where they normally reside. So if you are looking at getting a community treatment order, have a think about, are you able to get a bed in a hospital which is in the right area in order for them to be able to enact that community treatment order. And the final thing is to say that the court may specify a particular unit rather than just a wider hospital under Section 47 of the Crime Sentences Act. It's important to recognise that hospital orders aren't automatic. So the decision as to whether or not to make a hospital order is at the discretion of the court, and they can still send your client to prison. If the criteria at Section 37(2)A is made out, the judge should give detailed consideration to the factors set out in Section 37(2)B, which are the previous slides. But that does not compel the court to make a hospital order. They can still send them to custody. Now, as we know, the court must consider all options, including a hospital and limitation direction and transfer from prison for treatment under Section 47. And when deciding the most appropriate order, the judge should look at the welfare of the offender, the seriousness of the offence, and the importance of the penal element of the sentence, and consider their culpability and harm. Now, again, when you look at whether they're going to consider a hospital and limitation direction under 45A or just transfer under Section 47, again, I'd argue that this is where your expert is key. Ask them to address these issues in their evidence. Is a Section 45A or a Section 47 order appropriate? And if not, why not? And so, for example, examples why it might not be appropriate is the treatment actually available for them in prison? So if they're a patient who gets depot injections, are they able to get those depot injections in prison? Questions like how would prison affect the client's rehabilitation, I think, are key things to consider when looking at the different orders. And I think in terms of, again, think of the end, prepare for the question, why can't I just make an order under Section 47? I did one of these hearings before Christmas, and the judge just came straight out. He said, Mr. Smart, you're going to have an uphill struggle convincing me why we can't just make a Section 47 order. She'll be taken to custody today, taken out of custody to be made to feel better, and then go back to custody. So be prepared to be able to answer that. Mercifully, we were prepared, and she was granted a hospital room in that case. A couple of other considerations. A hospital order may be appropriate even though there's no causal link established between the offender's mental disorder and the offence in which the order is made. And also, just a quick note on magistrates, Section 37(3) deals with the power of magistrates to make hospital orders. It's where the court is satisfied that the person did the act or made the omission charged, and without proceeding to convictions, essentially you have a sort of mini actus reus trial. Although the case law would say that the power to do this is very, very sparingly used. And then just a quick thought about youths. There's no reference to a lower age limit when it comes to hospital orders, as there are with guardianship orders. So it's assumed that the lower age limit must be 10 years old, but only a youth court may make a hospital order or guardianship order on a child or young person. All right, so that's hospital orders in a little under 13 minutes. What we're now going to look at is hospital order with restrictions, which is, if you think back to the sentencing consideration, it's, well, should it be with or without restrictions? So, well, what are restrictions? Again, I'll go back to Archibald. Where an offence qualifies for a hospital order, but it appears to the court that the risk the offender poses to the public of serious harm is such that it's necessary for the offender's release and detention should be subject to further restrictions, in 41.3, the court may order that those restrictions shall apply to the offender. This is known as a hospital order with a restriction order. A restriction order cannot choose which of the restrictions in section 41.3 apply to the offender. If an order is made, and all the restrictions shall apply, and essentially that's paraphrasing from section 41. So let's look at this again. So it's again, where it appears to the court having regard to the nature of the offence, the antecedents of the offender, and the risk of committing further offences, if set at large, it is necessary for the protection of the public from serious harm to do so. No, the test is whether the offender poses a risk of serious harm to the public, not whether he poses a serious or significant risk of such harm. And the court is not bound to determine that issue by reference to the nature of any past violence. I think that's something important when considering these cases. Jones and Golding are worth looking at. The other thing to say is restriction orders cannot be made unless there is evidence that it is necessary to protect the public from serious harm, which is reassuring. However, it is that similar lowering of the bar when it's actually to say that the danger of a section of the public or a particular individual will suffice. So if you think about other orders where that's the test, it does somewhat lower the bar. As with section 37 orders, the decision as to whether or not to make a restriction order is entirely at the discretion of the court, and they're not bound by the medical evidence for or against. And a restriction order may be made even though the medical witnesses recommend that no restriction order should be made. And if the criteria at section 41 are made out, the court may make a restriction order, but it's not obliged to do so. Alternative sentences, including custodial, extended and life sentences, are available. Again, as with section 37 orders, there's no requirement of a causal connection between the mental disorder and the offence. And I suppose that we've been talking about restrictions. What are the restrictions? Well, the restrictions are set out at 41.3, and it's essentially that the powers of transfer and discharge of the patient are exercisable only with the consent of the Secretary of State. Essentially, it's keeping them in until somebody's satisfied that they can come out. Looking at duration, then, unlike hospital orders, restriction orders do not lapse unless renewed. They continue for as long as the restriction order is in place. Now, it is apparently somewhat rare that that's for a fixed period. If it is for a fixed period, then once that period ends, a hospital order continues in effect afterwards. And it's as if the hospital order was made on the day the restriction order lapses, although generally the case law would say that time limits on them are unusual and can be unwise. But discharge of the patient only happens when the patient satisfied the first tier tribunal that his or her mental health poses no acceptable risk to the public. And when they are discharged, it's conditional rather than absolute, and they are subject to recall, and that recall can be made by the responsible clinician, and the recall will be to the hospital rather than to custody. Another couple of considerations, it may seem trite, but a restriction order can only be made in conjunction with a hospital order. It cannot be made unless one of the section 32A registered medical practitioners, so this is one of our two experts, gives oral evidence. So the effect is that it's most likely that when you come to one of these hearings, you'll have to call one of your experts to give live evidence, because of course the court will have to consider whether there should or should not be restrictions. So you'll have to call one of your experts. Only the Crown Court may make a restrictions order. That's an interesting point, although the Magistrates Court can commit an offender over 14 years of age to the Crown Court for determination. And decisions on restriction orders are highly fact specific. For example, see Brooks, where the risk of serious harm was not made out by the repetition of index offences. There's also Lord Hughes gives a detailed explanation of the powers and considerations in AG Ref 54/2011. So that again is a whistle-stop tour of what restrictions look like. And so what then is the final thing that you have to consider, which is actually the first thing you have to consider, which is a hospital limitation direction. This time from Blackstone's, Hospital and limitation directions apply where the court has heard evidence that the offender is suffering from a mental disorder and the making of a hospital order is appropriate, but the court wishes to ensure that the offender, upon completion of the period of treatment, will thence be transferred to prison for the remainder of the sentence rather than being released from hospital. And as the sentencing of offenders with mental disorders, developmental disorders and neurological impairments guideline sets out, these are generally made in cases where long determinate or indeterminate sentences are being imposed. The laws at sections 45A and 45B of the Mental Health Act, 83, they're known as hybrid orders. And essentially what these orders are designed to do is cover the situation that Lord Bingham defined in Drew, which is the problematic situation which arises where neither a sentence of imprisonment nor a hospital order on its own appears appropriate in the case of a particular offender, and where the mutually exclusive operation of such disposals appears unsatisfactory. So the test for a hospital and limitation direction is that the court must be satisfied, again, on the written oral evidence of 2 registered medical practitioners, at least one of whom must give oral evidence, and that the offender is suffering from mental disorder, that the mental disorder is such a degree that it makes it appropriate for the offender to be detained in a hospital, and that appropriate treatment is available. So it's exactly the same as 37. And as with hospital orders, regular hospital orders, there needs to be a bed available for them. But if these criteria are satisfied, the court may make a hospital direction. And the direction is essentially that instead of being detained in prison, the offender is detained in a specified hospital. The effect is that if the offender, or when the offender ceases to require treatment prior to the end of their custodial sentence, they'll be returned to prison. And if a hospital direction is made, the court must also make a limitation direction, which is that the offender will be subject to the restrictions set out in section 41, as we just discussed, even if the criteria in section 41 aren't made out. So essentially, they cannot be discharged other than with permission of the Secretary of State. However, if the offender is in a hospital at the end of their custodial sentence and essentially the automatic release date, they continue to be detained in hospital, but as an unrestricted patient. And whilst a person is subject to a hospital limitation direction, the responsible medical officer must supply the Secretary of State with a report on the offender every 12 months. And it's important to say that these are only available for offenders aged 21 and over. I'll briefly, I note that I'm rapidly running out of time. There's some interesting stuff in here from the case law that talk about the relationship. I'll just talk about Fisher, I think, and then I'll stop and you can read the rest on your own. But Fisher considered the relationship between the orders and especially between section 37 and 41. It's essentially section 37 and 41 orders are not concerned with punishment, and release is governed by the first year tribunal and the responsible clinician. Section 45A orders, they do have a punishment element, and release is governed by the parole board, and that's going to be an important consideration when the judge is essentially looking at how they want this offender to be dealt with. And there's one other note: so where the fixed period of detention is considered appropriate, but the period is less than the treatment period required to allow discharge from the hospital, and punishment is a discrete purpose of sentencing under section 45A loses its force, and that's something to bear in mind. And this is because whatever route is taken, the offender will spend the custodial period in the same hospital and same circumstances. There are some other insights from the case law here, which I won't go through. You can read them at leisure. And the only other thing I'd mention is just when you're looking at this subject, have a look at interim hospital orders, which are section 38, and look at the post-arraignment pre-sentence provisions in section 35 and 36 for remand to hospital and for reports and treatment, because that might be something else we're looking at. The sentencing guidelines have got quite a good overview. It's quite basic and a bit rough and ready, but it is a good overview of the provisions. And then also have a look at criminal PR rules 28.8, 28.9, which set out the directions for commissioning medical reports. A bit of a whistle-stop tour, but hopefully we finished on time.
We did, Sam. Thank you very much for that interesting talk. And I suppose that's us finished for today. Like I said, any other questions, feel free to email either Sam or Tom. We're hoping to do another talk on 2 different topics towards the end of April. But as soon as it is physically possible to meet in person, I think we're going to be organising a J6 social drinks in the courtyard of Red Lion. So fingers crossed that is not too far away, but I anticipate that will be sometime in the summer if allowed. Apart from that, thanks everyone for coming. And like I said, this presentation will be on the website, and you can actually access the earlier presentations on different topics as well. They're also online. But unless anyone has any burning questions, I think we can end the talk here. Anything else, Tom, Sam? Great. Well, thank you very much for attending.